How did it happen? I can't recreate the cross-examination of Sergeant Bryce after the fact because he's already made his impression on you. I can't undo Your Honor's mindset with respect to his testimony. That horse has left the barn and we can't put it back in. I guess
He already told the judge no twice, under oath. Now he's sitting back on the stand, hand raised again, about to explain why no, wasn't exactly true. This is Sergeant Jeremy Bryce, an 8-year veteran of the Indiana State Police, and the reason a felony case against a man named Andrew Kosis might collapse. Not because of a bad search, not because of a technicality, but because of one word, answered wrong, in a deposition that nobody thought would matter. Here's what you're about to watch. A cop who found something on a suspect's phone that he probably shouldn't have found, a judge who believed him completely, and a defense attorney who just discovered that the officer's word, the entire foundation of the ruling, was built on a lie he told 2 weeks before the hearing that mattered most. Start with the search. Bryce was assigned to process Kosis's phone under a warrant. Somewhere in that process, he says, he stumbled onto something incriminating that fell outside what the warrant actually authorized. Not planned, not targeted. Just there, in his words, inadvertently. Last year, the defense challenged that. They wanted the evidence thrown out. The state's entire counter to that challenge rested on one argument: plain view. Bryce just happened to see it. And the judge, weighing everything in front of him, believed that account enough to let the evidence stand. Notice something here, because it matters later. Inadvertent is doing an enormous amount of work in that sentence. It's the difference between an illegal search and a lucky break. And the only person who can tell you whether it was one or the other is the officer himself. There is no camera angle for accidental. There is no forensic test for I just happened to glance at it. You either believe the man or you don't, which brings us to the deposition. October 27, 2025. Late in a long day of questioning, Bryce is asked a simple question. Have any complaints ever been filed against you as an Indiana State Police officer? He says no. No formal complaints. Clean record.
Correct. Have any complaints been filed against you while you have been an Indiana State Police officer?
If we're referring to internal investigations, as I believed you had meant during deposition, then the answer is still no.
No, I didn't refer to internal investigations. My question was simply, have any complaints been filed against you while you've been an Indiana State Police officer?
Knowing what I know now, with the complaint form of the inmate being filed and that being obviously recalled to memory, then I will answer yes.
And the complaint that was filed against you in federal court was a complaint filed against you while you're an Indiana State Police officer, correct?
It was on an inmate complaint form, so yes.
And in fact, it was a complaint that led to a lawsuit in federal court, correct?
It did.
And you had to have an answer, or an answer was filed on your behalf, correct?
It was.
You had to answer interrogatories, correct?
Correct.
You had to supply documents to counsel to respond to that lawsuit, correct?
That is correct.
And you even had to supply a declaration under oath in connection with a pending legal motion in connection with that lawsuit, correct?
The transcript comes back to him afterward. He reads it. Page 51, right there in black and white. He does not correct it. Here's where you're allowed to believe him for a second, because his explanation isn't crazy on its face. He says he thought the question meant internal affairs, official department discipline, not outside civil litigation.
And how did you understand the question that Mr. Schmid posed to you?
I took it as kind of a vague question, but I perceived it to be that it was asking about any internal affairs types of investigations or inquiries to our internal affairs division, to which my answer was no formal complaints.
It's a plausible read of an ambiguous sentence. Cops get sued constantly for the job itself, speeding tickets, arrests, routine friction. Maybe complaints really did just mean internal ones to him. For about 30 seconds, that theory holds.
I don't recall exactly why. I mean, it's been a while ago, but I will say it was towards the end of the deposition. There's obviously a little bit of question fatigue that sets in eventually. I took it to mean, any complaints made. I could have, I guess, assumed, any complaints made while I've been an Indiana State Police officer could have meant, have I made any complaints, which obviously would not really make sense in the context of the deposition. And so that's why I took that as any complaints made being, have I received any, formal complaints, any complaints that would be referred to our internal affairs investigation as a pre-inquiry or a true investigation. And so I'm sure that when I arrest people and take them to jail, that they may complain the handcuffs are on too tight, or when I've taken people to written speeding tickets to them, they've shown up to court. That would be technically a complaint because they're complaining that I stopped them for speeding and they were taking it to court. But that was the context of what the deposition was, at least in my mind. And so in my mind, I took that as an internal affairs complaint.
Then cross-examination starts pulling at it. Because it turns out Bryce wasn't just vaguely aware of some old paperwork. He'd been formally sued in federal court, by name, for allegedly violating a man's constitutional rights during...
How many times have you been sued in court in your life?
I've received a legal filing once. Never to the point where I went to court to testify on it, but just once.
So you've been sued in court once, correct?
Yes, I don't necessarily understand exactly what you mean by that, but I have a civil suit filed against me, yes.
Let me ask it this way. How many times have you been named as a defendant in a lawsuit?
Once, as far as I know.
And was that in federal court?
Yes, it was.
And was that in a lawsuit brought by a Stephen Hecky?
Yes.
Okay. And was that lawsuit filed in March of 2023?
Of all things, a cell phone search. He reviewed the complaint himself. He answered interrogatories under oath. He signed a sworn declaration for a summary judgment motion. This wasn't a rumor sitting in a filing cabinet somewhere. This was active litigation he had personally participated in months before the deposition where he said no. And here's the detail that quietly ends the internal affairs excuse for good. The very same deposition minutes earlier walked him through the details of the cell phone search in this exact case. The parallel wasn't buried. It was sitting right next to the question he claims he misunderstood.
Sergeant Bryce, can you point to the part of the question on page 51 when you were asked about whether any complaints have been made against you while an Indiana State police officer? Can you point to any part of that question that refers to internal affairs?
A courtroom doesn't run on what someone believes in their head. It runs on what they were willing to say out loud when it counted. And what Sergeant Bryce said under oath was measurably, provably false.
And you didn't make any corrections to your deposition transcript, did you?
I did not.
All right, so it's uncontested that this was not disclosed.
The defense's argument lands with surgical patience. 2 weeks after that deposition, Bryce becomes the single most important witness in the entire suppression hearing, the only person who can vouch for how he found that evidence.
Right?
Yes, Your Honor, in two respects. The first respect is that Sergeant Bryce gave false and inaccurate testimony at his October 27, 2025 deposition. The question that was asked of him asked whether any complaints had been filed against him while he was an Indiana State police officer. He answered no formal complaints. In fact, that was untrue. A formal complaint had been filed against him in federal court. He was well aware of it. He reviewed the complaint itself. An answer was filed on his behalf. He answered interrogatories, signed interrogatories under oath, and also submitted a declaration. So he submitted written testimony under oath.
His credibility isn't a side issue, it is the case.
His credibility, his testimony was critical, and the defense at the November 7, 2025 hearing was completely denied the opportunity to cross-examine him on the ground that he had given false testimony in his deposition.
And the defense never got the chance to cross-examine him with the one fact that might have changed everything the judge believed about him.
Evidentiary hearing in this case. Because of the egregious Brady violations, Your Honor, we believe that it's appropriate to dismiss the remainder of this criminal case.
But the law also says, Mr. Schmidt, that Brady violations are to be determined after trial. We don't even have a trial date.
The state pushes back the way institutions usually do. Call it immaterial, call it a misunderstanding, call it a distraction from the real question of whether the search itself was lawful.
Sergeant Bryce testified, Your Honor, that he inadvertently saw the reference in the snapshot of text messaging. We have to rely on his word and his word alone for what he saw and how he saw it. And we were denied an obvious impeachment avenue. A witness who has just lied 2 weeks before about an important material matter, the credibility of that witness obviously would be severely adversely affected.
But the judge says something quieter, more damaging than any accusation could be.
Prosecutors are obligated to find out the information and to disclose it to the defense. Prosecutors can't bury their head in the sand and not ask their witnesses, fail to ask them, any complaints been made against you? Anyone accused you of constitutional violations before? Anyone accused you of lying? You ever been disciplined for lying before? In some prosecutors,
He admits on the record that he didn't know any of this when he made his ruling.
right, I'm not asking to reopen and get a second crack at the apple. I'm just saying what should be the appropriate sanction for an obvious disclosure violation by the state. And I'm just saying one additional remedy that Your Honor could consider short of outright dismissal of the whole case is to strike Sergeant Bryce's testimony. I believe that in that instance, Your Honor would then grant in full the defendant's suppression motion because there'd be no plain view to.
The horse, as the defense attorney puts it, has already left the barn.
I do want to state for the record, I was unaware of this lawsuit until Mr. Schmid brought it to my attention in January.
To be clear, Mr. Luttrell, I wanted that clear on the record too. I don't think anybody is sitting here accusing you of misconduct.
Secondly, I want to.
That's the sentence worth sitting with. Not because it's clever, because it's honest. A courtroom decision, once made, doesn't happen just because new facts arrive. Trust works the same way outside these walls. You don't get to quietly walk back a lie after it's already changed what someone believed. The judge hasn't ruled yet. His order is due by June 1st. Whether that ruling holds, gets narrowed, or falls apart entirely now depends on whether one overlooked word in a deposition outweighs everything Sergeant Bryce swore to on the stand. And we'll be here when the answer comes down.
At the conclusion of a lengthy deposition,
Court's order on